Hello and welcome again for another special edition of a business education talk. Today, we have a special guest coming from the legal industry of real estate. And I'm really excited to see the different perspective that he will share with us. Andre Ong is a well-known accredited property law specialist, and is also the principal partner at Sharrock Pittman Legal. Andre, thank you very much for joining this talk. And if we could start with a bit of your story and how did you get started in your business?
Thank you very much, Alan, and obviously a pleasure to speak to you and all of the watchers here today. So in terms of my journey into property, I guess Australia overall has a very strong interest in property. When I worked through my law degree and went into practice, looking around at areas of active interest, property was certainly a key area of commercial activity, and one where you could really make a difference in someone's life, whether it's helping them buy their first home all the way through to large-scale development, or getting rid of problems that they might have with covenants or easements, restrictions, etc. It's certainly an area that has a lot of interest, a lot of variety, and really makes an impact with people.
Okay, beautiful. Yeah, that's quite interesting, isn't it? Yeah.
Absolutely.
So in your view, I mean, since you sort of started your career, how did you see the market evolving, from a legal perspective?
Absolutely. So look, I've been in practice since 2004, and that obviously, looking back through that time, the main change in terms of the legal aspect of things has really been the rise of consumer protection as a fundamental issue that has to be dealt with and considered, right, as well as a lot of moves by governments, both state and federal, to really tighten up tax regimes as well. So it's really important when you're working through any development or any property matter per se, to really consider those different aspects. So when you start going out there into the marketplace, and this obviously relates to both the buying and selling perspective, if you're buying, at least you know that there are some government protections in place with respect to material disclosure as a new thing, with respect to some limitations around off-plan sales. Those sorts of legal topics, legal areas have been tightened over the years, and in some cases more than once, with the government really looking towards trying to protect the consumer from buying something that they didn't intend, or being surprised once they'd acquired, or at least, even if they are surprised, that there are rights there for them to take action against a vendor who's done the wrong thing.
Yeah.
Similarly, on the tax side of things, and obviously having just gone through, and we are still going through the pandemic, governments are definitely looking at making sure their tax base is protected, making sure that they're looking at it from a property perspective, especially from a state stamp duty perspective.
Okay.
It's definitely an issue all around Australia, where state governments have been looking at ways they can extract some tax out of transactions, and it is important there to make sure that you've got your structures correct and that you are really getting the right advice from a good team at the outset.
Right. That's
To
really
make sure that
interesting.
you're not tripping over yourself.
Okay, yeah, that's really interesting about just getting that structure right from the start, isn't it? Because I know from my experience myself, and also from other developers, if you don't get the foundation right, then you find that there might be some tax implication down the track, which might be even more costly to get fixed later on. Yeah.
Yes, absolutely, and it's one of the fundamental things, I think, that is a common trap, and a good reason for people to get advice and to get input, and really educate themselves and get the right sort of advice from professionals as well. That the structure is the way it needs to be for what they're intending, and factoring in not only their financial aims, but also the tax regime that's there, the tax framework that's there, and making sure that you don't make a mistake at the outset that's going to cost you tens of thousands down the track, and really for the sake of just getting yourself some good advice and some good learning at an early point.
Okay. So in terms of those type of mistakes, when clients approach you, is it then too late to unravel those mistakes, or how do you sort of deal with that sort of issues and challenges?
Sure. I mean, obviously, in an ideal world, you have the clients come and see us at a very early stage before they've even acquired the intended development site for subject property. But if that's not the case, and we are coming in at a later point, or even at a point when there has been an assessment, an adverse assessment made by either State Revenue Office or ATO, there's certainly some options there. I suppose the key takeaway from it, though, is that the later you're coming in to get the advice, the more limited the options that you have. So certainly, if we are addressing, say, a stamp duty issue or things like property entitlement duty, that sort of thing, or development impacted duty, that sort of thing, where things have happened during a transaction that has triggered a stamp duty liability, and we're only addressing things at that point.
Yeah,
there's a certain amount that we can do to try and argue a particular position. But if your structures are set up incorrectly, things are signed already and dated already, they are really irreversible points. And certainly, as I think a key example for everyone to know about is the present, I guess, crackdown, for want of a better word, with respect to nominations of purchasers and land development. So the State Revenue Office has tried to, with the ruling, clarify that, but the issue has been that they haven't really been able to clarify it with that ruling. The SRO have a very broad interpretation of what land development might be, including getting feasibilities, drawings prepared, that sort of thing. And if those actions are happening between the date a first purchaser signs a contract and the date the nominee takes the right to complete that contract, you're going to have a double stamp duty problem. And it's one of those things, again, you need to get some early advice on to make sure that, when you're buying that property, and you might be buying it initially in your own name or a partner's name as an individual while you're waiting to set up your structures, just being aware that that period of time between that contract date and when your structures are set up and you complete that nomination, if there is land development in that period of time, noting that very broad definition of land development, you're really asking for trouble from the SRO, unfortunately. So it's really a situation where, again, make sure that your professionals that you have on your team know what's going on, that your lawyer, your accountant, your conveyancer, that they all know what's happening so that they can properly advise you as to the right thing to do and when.
Okay, beautiful. Yeah. Look, let's talk a bit about maybe when you started your career in terms of what really motivates you and inspires you to continue and provide value to your clients in your legal profession. Why are you doing that every day, not just getting up and then provide the sort of thing? And at least you understand the rationale behind it. It's not just about providing legal advice, but what's the bigger picture in terms of you're trying to achieve?
Yeah, absolutely. I think that the main rationale behind my career really is to be able to help people live their better lives. I mean, ultimately, property, whether it be your own home or a development, is a life-changing sort of asset. You're in a position when you're dealing with something with a very high value and a very high potential of gain in value if people are handling their affairs correctly. It's really something that can help someone's life, and that ultimately is the buzz out of all of this. Yes, there are lots of technical ins and outs and getting a good win here or there as against another party or against a tenant or landlord in a lease dispute, or a vendor or purchaser if there's disputes in the sale situation. Sure, those are fulfilling in their own way, but ultimately the idea is really to be helping people live their best life. Ultimately, helping them really put their stamp on the world when we're talking about property, and being able to see the reality, not just pushing paper around, but to see the reality on the ground of, a site that's been built from what might have been a small residential home is now a 7-story, hospital grade building that I've worked on. That sort of thing. It really does give you a buzz, and really, obviously, seeing the clients have that achievement, which you've had some small part in, and that's certainly extremely fulfilling.
Yeah, I totally agree. I mean, seeing that you've been part of that project somehow in terms of helping the developers or the client in terms of achieving that successful outcome, then you have that stamp. Okay, we provided advice to that client, and this is the sort of project that he's been able to deliver, and so on, isn't it?
Absolutely, Alan. I think I'm sure it's the same in your situation as well. It's really helping people, helping people achieve their dreams. Really, we're talking about transactions that have that kind of impact. So it's really quite fulfilling.
Beautiful, yeah. Now, I think you mentioned about a couple of issues that you were resolving for your clients. So in terms of, without disclosing any confidential client information, I understand that. What types of project are you assisting your clients at the moment, so that we get a bit of a sense of the understanding of the level of complexities that you're solving for your clients?
Sure. Not a problem at all, Alan. So I think we'll start with, since we were just talking about structuring, we'll talk about some of the nitty-gritty of property law in a sec, but I think let's start with the structuring side of things, given we were just talking about that.
Yeah.
There certainly is presently a lot of people joining up together, with the prices of property these days as the prices continue to accelerate, and obviously that has a plus on once the development is ready and they're proceeding with the sale. But there's certainly a lot more people who are partnering up, who are doing things together within trust structures, company structures, that sort of thing. And again, talking about the stamp duty aspect, that's one side of things to get right, to make sure you're not tripping over and paying excess tax where you don't need to. But secondly, when you're talking about people doing deals with each other, it's important to understand that you've got parties, 2, 3, more parties who are coming into a project with possibly different intent at the end, possibly different backgrounds, different perspectives. And you really want to make sure those ground rules are set early. What are the intents of the parties in this? What do they want to achieve within this particular project or set of projects, not necessarily just one development, for example. Having that discussion early, and then having that discussion fed back into your lawyers, your accountant, to make sure that you are setting up a structure, be it a company or a unit trust as an example, or even partnership or discretionary trust. You're setting up a structure where you actually have the right control mechanisms that work for you. I've had probably too many people on the other side of things where everybody was very happy at the beginning. They shook hands, everything started, and then someone's life had changed, or there was an impact from outside in terms of a family law matter or a separate business dispute that has then flowed back into a development project and ground things to a halt. I mean, that's obviously the worst thing that can happen when you've got holding costs, etc. To be getting a development to stop in the middle because of a dispute between the parties. And in scenarios like that, the first thing I tend to ask for, obviously, is always your partnership agreement, or your shareholders agreement, or your unit holders agreement. Where's the documentation to confirm what is actually each party's responsibility? What's supposed to happen, say in a worst case scenario, if someone is incapacitated, or in the event of a dispute? Have you really thought through those ground rules of what's going to work between the group as they do this development, so that nothing gets in the way and everyone achieves what their actual aims are? And unfortunately, it's not something where we can go back into history and sort of unscramble the egg. It's a situation where, again, looking at things from our client's perspective, it's a situation where if you're coming to me at a late stage, sure, we can fight things from that position. Most likely, if there are no agreements in place and we're talking about a substantial dispute, well, off to court we go. And that's obviously expensive for everyone. And that's certainly something we try to avoid where we can and work towards mediated resolutions. But it is so much easier and so much more powerful for people if they've actually got the documentation in place at an early stage. Everyone's happy at that early stage. Everyone's got a much clearer perspective on what they want, where they're heading, and also what they're risking at that point. And even though, obviously, as with life, anything, things change over time. And as things change, sure, you might have to tweak agreements and deal with those changes. But the reality is then you have at least a strong starting point to work through. So yes, that's one aspect of my work, to make sure that people are getting that structuring advice early, putting their agreements down in black and white. And yes, that's obviously a bit of an upfront cost, before things get really meaty through the development. But when you're talking about the kind of money you're talking about with any property development, it is fundamental when you're having people coming across. And unfortunately, I've seen situations even within families where there's a heavy falling out and just massive consequences throughout a development group because people haven't really codified their relationship properly. So that's on a commercial and property aspect to make sure people have those agreements in place. On the more technical side of things, what we've been running into, I guess, is a perennial sort of issue with different properties, and I guess also as a bit of a reflection of the COVID/post-COVID market. There's a lot of people who've acquired sites that maybe are not perfect. They've had there might be a boundary issue with a party wall easement. There might be a restrictive covenant over the top of it. That has been a little bit of a reflection of the lack of stock. So the property might well be in a good spot, very accessible to transport services, all of the things you look for, as I'm sure you would be advising people, Alan. But they would have an issue on it, a restricted covenant that might prevent the kind of development that you're after. There might be a problem with a boundary not aligning, or maybe having a party wall, dealing with one at the minute where there's party wall easements, and that is holding up significantly a multi-factory development. Those sorts of situations come up, and again, the earlier you can spot them, the better, but also factoring in the time that it'll take to work through those issues when you're considering your development. Because these sites, given that there are those issues on them, certainly when people were looking to acquire them, I'm sure they'd factor that into their offer prices. But it is important to consider that. And then also the risk that you're taking, because there's no guarantees with covenants, as an example. There's no guarantees that they will be buried or removed. Council very much, you've got a couple of choices there. Council is usually the lowest cost, albeit riskier option, in that if there are objections from neighbours against the variation or the removal of a covenant, a lot of councils will just use that as a reason to reject your permit application to have the covenant buried or removed. Then you're left with having to go into VCAT to fight that out. Now, we've had a lot of success in that VCAT process. That might have something to do with the council's just reaction of refusing variations or amendments easily, so variations or removals easily. But again, you've got to factor in the time of dealing with that.
As much as possible, if you can avoid the VCAT, to even go to VCAT, that's better for us in terms of holding costs and so on, isn't it?
Yes, absolutely. And especially when using covenants as examples, especially if your alternative to permits and VCAT is to go straight to the Supreme Court. There's a lot of cost to be dealt with there. And unless you're looking at a site with the margin to allow that
that sort of delay.
So you really have to be factoring that in. But like I said, the sort of low stock environment that was running through COVID has resulted in some of those inquiries coming through, and we've been able to again get some good wins there with council, just as a bit of a hint, a tip in terms of those covenant issues. When you're making the application to have a variation removal, you will need a lawyer to put a letter to council to explain who's benefiting from the particular covenant and why the removal of variation won't have a real or perceived detrimental impact on the people that benefit from that covenant. And that's really the technical way to argue it out. But it is something you need to allow a few months for, as I'm sure everyone knows, council does not move in the speediest way. And then links to, I was talking about boundary issues as well, that links to other matters that we're dealing with boundary issues. When, and that includes adverse possession, we do a lot of that as well, where you've controlled a piece of land over 15 or more years, and that might be you and past owners joined together. You can make an adverse possession application to have the title of that controlled piece of land transferred to you, really on the basis that no one else has used it in that time, or there's been no recognition of the true owner's title over the land in that time. Certainly.
Is it still about 15 years now?
Yes, correct. The time frame is 15 years. It doesn't just have to be your period of ownership. It can go back through to past owners. I've had several lately that have relied on that sort of provision, not necessarily just development sites, also a little bit on the farmland side of things, where people have just, I guess, it's the country, the cattle have always been grazed in a particular space, and we might be talking about acres of land, but ultimately titles have been corrected. And someone, in fact, eventually has to pick up the ball and get that amended, and ultimately to their benefit, because obviously the title vests and you've got the correct title in your name, etc. Little bit of a laborious process, making sure your evidence is in the right spot, and having independent witnesses to confirm what you're doing. But that, again, is a bit of an example of some of the more technical aspects. Back on the development side of things, certainly do a lot of industrial and commercial work in terms of sales, purchases. Industrial land at the moment is selling like hotcakes from what my clients tell me. There's a lot of demand out there with industrial development, and that creates its own issues. There's a lot of greenfield sites we deal with out in that southeast corridor. As Melbourne grows, that's where the industrial land's really zoned. And there's a lot of work out there making sure that those sites are suitable for the development that's intended, addressing possible contamination issues when you're converting one use to another, that sort of thing. And then with those prospective development sites, as I'm sure that the viewers might be aware, people want to enter into long-term purchase contracts so that they've got the time to be working through those permit steps, maybe even get on the site and start doing some preliminary bits of work there. So there's certainly been a lot of movement in doing license agreements and making sure those are termed to give the exact level of rights that are needed and what payments, if any. Sometimes people are paying sufficiently for the property that the license is granted just as a part of the contract. And again, these are things that really it's good to get input from your professionals as well as people like yourself, Alan, to people who know what they're doing within the space. And to get that input to go, okay, you've got that particular site. How do you structure the deal so that it makes the most sense? There's no added benefit in having a year's extra holding costs if you can get a sale contract that's got a 1-year settlement date on it. And you might be paying a little bit for that in terms of the price, but the fact is you haven't got that holding cost. The vendor is paying the outgoings. As long as you've got access and your consent rights to enable your development permits to proceed, well, so much the better for you. You've got much less risk within that context. So there's been a little bit of that sort of thing. So I guess that's a little bit of a smattering of the various bits and pieces that keep you busy through the day, as well as your usual sales, purchases, leases. I do a lot of leasing work as well. Is that
commercial and industrial?
Yes, correct. So I suppose that there is a variety in terms of the property space and what people should be considering from an investment and development perspective. Sure, residential is the most hands-on. It's easiest to understand in that, we all have a house, we all understand sort of that space and even that rental space.
Yeah.
But just understand that there is a mix of property assets out there, and each of them have their own risks, each of them have their own opportunities. I guess industrial land there is a bit of an example. As I said, there's a lot of subdivision and development happening in the outer southeast and on the other side of town in the northwest and north, where there is really strong activity happening, and that's subdivisions, people being able to secure leases and sales as well, doing that kind of development. So certainly doing a lot of that.
So in terms of the residential development, so can you give us a bit of a spectrum of clients you deal? Is it just in townhouse space or apartments or land subdivision? So then at least it gives a bit of a overview what you guys deal with, so that our audience can understand your core expertise.
Yeah, absolutely, not a problem. Look, I'm an accredited property law specialist. I've got a team of property lawyers that work with me basically to deliver results for people. In terms of the residential development space, we've done everything from your garden variety 2-lot subdivision right through to multi-lot apartments or greenfield sites as well. Out in the outer, I guess, the very edges of Melbourne, urban growth boundary stuff, that sort of thing. And even in regional areas as well. In the development space, I think it's important not to be constrained sometimes by what might be your immediate geography. Understand that there are opportunities everywhere, and from a Victorian kind of context, certainly we've assisted people all throughout the state. There are times when there's been a lot of work up at Mildura or out towards Gippsland. We've been doing a lot out there lately. That's a very strong growth corridor for Melbourne, and it's really from, I guess, the legal work standpoint. We follow where the work is, and it's not really an issue of where we are based geographically. It's an issue of where the actual activity is, and we'll have clients who are city-based or even interstate-based who are doing developments out in country Victoria or out in the very fringes of Melbourne, and it's irrelevant where everyone is geographically because the legal context is the same. And the expertise that we're delivering, the value we're delivering is the same. So it's really just making sure that the opportunity stacks up for the client, that they've really worked their feasibilities, they understand what they're going to get out of this and what those risks are. So really speaking to me, to any lawyer, frankly, but speaking to someone who knows what they're talking about at the outset, even at that contract stage, sure, you might have seen, dozens and dozens of contracts and vendor statements. But again, when you're talking about your particular one that you're about to sink your money into, you might want to just have that last check by a professional to make sure that, any problems, sure, they might just tell you, as you might have expected to hear, that, yep, no problems, everything's stock standard, great. But at least you've had that reassurance, number one. Number two, if that professional happens to be wrong, you can rely on their insurance from a negligence perspective. And certainly for people who unfortunately run into that scenario with others, they've come to see me to get our litigation team to progress that sort of negligence action against other people.
And this is very important because I always hear people say, I don't need to consult a property lawyer. My conveyancer have enough knowledge to advise me on some of those type of transaction. So can you comment on that a bit? Yeah.
Sure. I think, look, the role of conveyancers, and I don't have anything against conveyancers per se, because our firm actually does support some conveyancing firms in terms of giving them back-end advice on things that are I guess, more complex. It's a horses for courses issue because if you have a very straightforward sort of transaction, and I fully acknowledge that there's definitely a cost saving to be had. Conveyances can be variable in quality and cost, but you can get a reasonable conveyancer for a little bit cheaper than what a lawyer would charge.
True.
But the reality is, what are you planning to do with that property? And what's the extent of knowledge that your conveyancer actually has? Because